Tantor Audio, a division of Recorded Books, presents Agreeing to Disagree: How the Establishment Clause Protects Religious Diversity and Freedom of Conscience, by Nathan S. Chapman and Michael W. McConnell. Narrated by Walter Dixon. We sponsor an attitude on the part of government that shows no partiality to any one group, and that lets each flourish according to the zeal of its adherents and the appeal of its dogma. Zorak v. Clausen, 343 U.S. 306 at 313, 1952. The Church must be reminded that it is not the master or the servant of the state, but rather the conscience of the state. It must be the guide and the critic of the state, and never its tool. Martin Luther King, Jr. A Knock at Midnight, in Strength to Love, 57, 1964. Introduction. The Establishment Clause of the First Amendment may be the most contentious and misunderstood provision of the entire Constitution. It reads, "Congress shall make no law respecting an establishment of religion." It lies at the heart of America's culture wars, but what exactly is an establishment of religion, and what is a law respecting it? When those words were added to the Constitution, every American lawyer, and probably every citizen, knew what they meant. As British subjects, Americans had long lived under the church by law established, with some colonists embracing it and others dissenting from it. 2 of the 13 original colonies never had establishments of religion. 2 had intermittent and largely notional establishments, and several others scuttled their establishments at independence. When the First Amendment was adopted in 1791, however, roughly half the states still maintained some form of establishment of religion. There were lively debates in the early decades in almost every state over whether to retain, dismantle, or resurrect a religious establishment. Whether for or against establishments, everyone knew what they were. The national government never had a religious establishment. The First Amendment saw to that, and the last state establishment of religion, in Massachusetts, was formally dismantled in 1833. The term establishment of religion thus passed from usage. Today it has no reference outside of constitutional law. Some of the legal practices that constituted an establishment have contemporary analogues, but some of them do not, and in any case, the legal attributes of a church by law established have been lost to history. To make matters worse, the Supreme Court has offered conflicting, changing, and ambiguous interpretations. After near radio silence on the provision for more than a century, the Court decided in Everson v. Board of Education, 1947, that the clause applies against the states, and turned to history to interpret its meaning. The justices zeroed in on a narrow range of evidence, interpreting the clause to erect what Thomas Jefferson called a wall of separation between church and state. So confused were the court's cases that the distinguished legal historian Leonard Levy commented that the Supreme Court would not recognize an establishment of religion if it took life and bit the justices. In Lemon v. Kurtzman, 1971, the court triumphantly announced a test to implement this separationist vision of the clause. The aptly named Lemon Test was unfortunately vague, misleading, and ungrounded in history or principle. Since then, the court has gradually abandoned the Lemon Test, but it has not substituted a new one, leaving Establishment Clause cases to be governed by a collection of context-specific rules, many of them the virtual opposite of the prior understandings under Lemon. No other constitutional provision has experienced such interpretive tergiversation. But that is not all. The First Amendment contains 2 provisions about religion, yoked together in a single grammatical unit. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. This is the only part of the Constitution that comprises 2 rules with 2 different verbs, respecting and prohibiting, and 2 different objects, establishment and free exercise, but a single topic, religion. What is the relation between these 2 provisions? The simplest and most sensible possibility is that they are mutually reinforcing. The Free Exercise Clause protects the right to practice religion according to conscience and conviction, and the Establishment Clause prevents the government from coercing or using governmental power to induce religious beliefs and practice. Thus, no one may be punished, penalized, or prevented from engaging in religious practice, and no one shall be compelled to frequent or support any religious worship, place, or ministry whatsoever, in the words of Thomas Jefferson's Bill for Establishing Religious Freedom, adopted in Virginia in 1786. Under this view, which we defend in this book, the religion clauses work together to prohibit the government from using sticks or carrots to induce uniformity of religious belief and practice. But many think that free exercise and non-establishment point in opposite directions. Indeed, the modern Supreme Court has repeatedly said that the two provisions are in tension. The tension arises from the widespread idea that the point of the Establishment Clause is to protect the secular public sphere from the dangerously divisive and irrational impulses of religion. The purpose of the Establishment Clause, in this view, is to reduce the influence of religion in the public sphere and consign it to the private realm of individual, family, and church. Throughout this book, we abide by the legal convention, using the term church to include the organizational forms of all religious faiths, synagogues, mosques, temples, kiva societies, etc. Many of the most difficult and recurring controversies over the religion clauses hinge on which of these understandings to follow. May the government exempt religious believers from compliance with legal obligations applicable to others, such as military conscription or drug laws? May the government include religious schools or other service providers in spending programs open to their non-religious counterparts? May religious speakers offer prayers at public events where non-religious speakers would be free to choose their messages? In all these cases, the first view would lead to an affirmative answer, and the second to a negative. Taken to its logical extreme, the second view even suggests that the two religion clauses contradict each other. If the government is forbidden to give benefits or support to religion, as the Court's Establishment Clause cases sometimes say, is the Free Exercise Clause itself unconstitutional? Special constitutional protection for the exercise of religion, and not other belief systems, sounds like a benefit and a preference. And if the government is forbidden to deny benefits to an entity solely on the basis of its religious status, as the Court's Free Exercise cases sometimes say, doesn't that render many of the Court's Establishment Clause cases, such as those forbidding aid to religious schools, unconstitutional? A third possible relation between the two religious clauses is that they address different types of questions. The Free Exercise Clause is a classic protection for a specific liberty, not unlike freedom of speech or property. The government may not prohibit the exercise of religion, meaning that it may not penalize or prevent it. But the Establishment Clause is a structural provision, akin to the enumeration of powers, declaring that Congress, meaning the federal government, has no authority over, respecting, the specific subject area of religious establishments. It is difficult to understand, under this theory, how the Establishment Clause could logically have been applied to the states as one of the individual rights provisions incorporated under the 14th Amendment. Even more than other provisions of the Constitution, then, the correct interpretation of the Establishment Clause is a matter of deep uncertainty and continuing controversy. And these uncertainties and controversies matter. The proper interpretation of the Establishment Clause tells us much about the character of the American Republic and our political culture. Does, or should, religion have a privileged place in that culture? Or does the First Amendment, properly understood, require exclusion of religion from the public sphere? In other words, does secularism have a privileged place? Or is the Constitution agnostic, neutral on the question, leaving the degree of religious influence on the public order to be decided by the people themselves through decentralized and deregulated institutions? This book will address these questions in two stages. We will first explore the history of establishment and disestablishment in the United States. Virtually all the justices of the Supreme Court, even those not ordinarily regarded as originalists, have maintained that in deciphering the religion clauses, The line we must draw between the permissible and the impermissible is one which accords with history and faithfully reflects the understanding of the Founding Fathers," quoting Justice William J. Brennan, Jr. Starting with the original meaning of a constitutional provision almost always makes good sense, but especially when that provision refers to legal arrangements that have gone the way of the dodo. Imagine applying Congress's power to grant letters of marque and reprisal without understanding the law of maritime warfare circa 1789. The trouble is that the history of religious establishment relied on by the court has been radically incomplete and often misleading. For a more complete understanding, we must examine the scope of the British, colonial, and early state establishments, attend to the debates over the Establishment Clause in the First Congress, and trace the process of disestablishment in the states. We then turn to the most significant areas of modern disputation: education, both religious exercises in public schools and the legal status of private religious schools; public funding of religiously related public services; free exercise accommodations, including exceptions from general laws to respect religious conscience; regulation of the internal decisions of religious organizations; and public religious symbols. In each case, we explore how the historic principles of disestablishment should apply to the circumstances of our day. The fundamental point that emerges is that the Establishment Clause is not a thumb on the scale for secularism in public matters, let alone the opposite, but a constitutional commitment for Americans to agree to disagree about matters of religion, to refrain from using the power of government to coerce or induce uniformity of belief, whether that belief is Christian or non-Christian, secular or religious. All faiths are free to flourish or not, according to the zeal of their adherents and the appeal of their dogma, not according to the will of the majority, the power of elites, or the authority of the state. Unlike most treatments of this issue, this book will focus on the establishment of religion as law. We will not attempt to contribute to the vast literature on Locke, Hobbes, Spinoza, Rousseau, Bayle, Mill, and other philosophers, and their views on the relation of religion to government. Instead, we will explore changes in enacted laws and constitutions, and the arguments for and against those changes in legislative debates, courts, petitions, newspaper essays, and speeches. These debates may not be as profound as the philosophers, but they tell us what disestablishment was really about. Part 1. History. Chapter 1. Establishment at the Founding. Many of the words of the United States Constitution sound like ordinary English of the 21st century. We are familiar with the words speech, property, law, and search. Establishment of religion is different. It has been so long, 190 years, since any state in the Union has had an establishment of religion that we have almost forgotten what one is. When the words, "Congress shall make no law respecting an establishment of religion," were added to the Constitution, though, virtually every American knew from experience what those words meant. They would continue to debate some of the details for generations, but the basic contours of an establishment of religion were well understood. The Church of England was established by law in the mother country. 9 of the 13 colonies had established churches on the eve of the Revolution, and about half of the states continued to have some form of official religious establishment when the First Amendment was adopted. The pros and cons of religious establishment were hotly debated from Georgia to Maine. Unsurprisingly, when the Supreme Court in the 1940s began to decide cases about an establishment of religion, it turned to founding-era history. As Justice William Brennan, ordinarily skeptical of interpretation based on history, suggested 2 decades later, the question is, what are those substantive evils, the fear of which called forth the Establishment Clause of the First Amendment? Unfortunately, though, the court made no serious attempt to canvass the history of establishment, whether in Britain, the American colonies, or the early American states, or to distinguish between the First Amendment and various conflicts over establishment at the state level. Instead, the justices focused on one event in the state, the rejection of Patrick Henry's Assessment Bill in Virginia 1875 in favor of Thomas Jefferson's alternative Bill for the Establishment of Religious Freedom. Without surveying the legal institutions of establishment, the arguments advanced for them, or the broader history of disestablishment, the court asserted that the provisions of the First Amendment had the same objective and were intended to provide the same protection against governmental intrusion on religious liberty as the Virginia statute. Based on this truncated history, the court declared the animating principle of the Establishment Clause to be the separation of church and state, an overly simplistic notion that proved far more judicially pliable and far more hostile to religion than anyone in the founding generation could have imagined. The true evil of religious establishment, contemplated at the adoption of the First Amendment, was the use of government power to foster or compel uniformity of religious thought and practice. Though the details differed by jurisdiction, establishments all relied on an array of legal devices designed to bring about religious uniformity and discourage religious dissent. These included laws restricting public office to members of certain religious groups, laws requiring church membership, attendance, or financial support, and prohibitions on dissenting forms of worship. It is no coincidence that the statutory centerpiece of the British establishment was entitled the Uniformity Act. At the founding, a majority of the states had these sorts of laws, and Americans understood them to be the essence of religious establishment. We must also examine why so many Americans defended religious establishments. In the Supreme Court's version of the story, a large proportion of the earthly settlers of this country came here from Europe to escape the bondage of laws that compelled them to support and attend government-favored churches. The transplantation of established churches to these shores became so commonplace as to shock the freedom-loving colonials into a feeling of abhorrence, leading directly to the First Amendment. One would never know from the Justice's careless description of history that no small number of the freedom-loving colonials considered official sanction for religion natural and essential, that the movement toward disestablishment was hotly contested by many patriotic and Republican leaders, and that there were serious arguments, not mere feelings of abhorrence, on both sides of the issue. The Justices never analyzed any of the books, essays, sermons, speeches, or judicial opinions that set forth the philosophical and political arguments in favor of an establishment of religion, and relied on only one of the hundreds of arguments made against establishment. A broader base of understanding is essential for recognizing what establishment of religion was, and why Americans ultimately abandoned it. Establishments in the colonial period. Before independence, the Church of England, now known in the United States as the Episcopal or Anglican Church, was the church by law established in the mother country, in the 5 southern colonies, Maryland through Georgia, and in 4 counties of metropolitan New York. This Anglican establishment was top-down, hierarchical, and governed by the Crown, Parliament, royal governors, and local landowners. New England, outside of Rhode Island, had a different kind of establishment. The settlers of Massachusetts, Connecticut, New Hampshire, and Vermont were mostly Puritans, later called Congregationalists, members of a branch of Reformed Protestantism based on the teachings of John Calvin. The establishment of religion consisted of a complex web of statutes and executive pronouncements, which varied in their details, even among the Anglican establishments, and even more so between those establishments and the Puritan establishments of New England. Despite their differences, though, there were many common elements. Americans understood those elements to be an establishment of religion. Establishment in England. The established Church of England had deep roots. When Henry VIII broke from Rome in 1533, his intent was simply to replace the Pope with the monarch as head of the English Church, largely preserving Catholic religious practice. The Pope was stripped of authority to name bishops in England, to control its liturgy or articles of faith, and to receive revenue from religious taxes. All these powers devolved on the king. The 1534 Act of Supremacy made the king the supreme head of the Church of England, and gave him authority to reform and redress all errors, heresies, and abuses. During the reign of Henry's son, Edward VI, Parliament assumed a larger role, and the Church of England shifted toward Protestantism. In subsequent decades, convocations of churchmen composed and Parliament enacted the 39 Articles of Faith, which set forth the doctrinal tenets of the Church, and the Book of Common Prayer, which determined the liturgy for religious worship, later prescribing use of the Authorized or King James translation of the Bible. The Acts of Uniformity of 1549, 1559, and 1662 required all ministers to conform to these requirements, making the Church of England the sole institution for lawful public worship. Their purpose, as stated in the preamble to the 1662 version, was to effect a universal agreement in the public worship of Almighty God. When an early draft of the First Amendment forbade Congress from enacting articles of faith or modes of worship, the framers had the 39 Articles and Acts of Uniformity in mind. The English establishment was largely unconcerned with people's internal consciences and beliefs. Few were prosecuted for heresy after Elizabeth acceded to the throne. There was no inquisition to ferret out nonconforming opinions. Dissenters from the Church of England, mostly Catholics, radical Protestants, and Quakers, could usually employ their priests or ministers and take their sacraments in private chapels, so long as these were not open to the general public. This is likely one reason the framers of the First Amendment chose to protect the free exercise of religion rather than mere freedom of conscience. The establishmentarian tradition from which they broke prohibited religious exercise outside of the state church and left private conscience largely uncoerced. The Toleration Act of 1688 suspended the penalties for violation of the Uniformity Acts for Trinitarian Protestants, Presbyterians, Independents, the English term for Congregationalists, Lutherans, and Baptists. It was not until the mid-19th century that Catholics, Jews, Unitarians, and others gained the freedom of public worship. Two other sets of statutes, the Test and Corporation Acts, limited civil, military, ecclesiastical, and academic offices to participating members of the Church. This had two, maybe three effects. First, it ensured that the government, the military, the courts, and the universities would be run by people who shared the governing assumptions of the realm, most particularly the supremacy of the king in England and the lack of authority of the Pope in Rome. This was an obstacle to the efforts of James II, a Catholic, to protect his position by naming Catholics to high position in the army and the administration, and to any effort by radical Protestants to bring about a reprise of the Commonwealth. Second, the Test and Corporation Acts provided an incentive for ambitious members of the ruling class to conform to the established church, at least outwardly, and bring up their children accordingly. This was probably a more effective instrument of conformity than outright coercion, but the primary effect of the acts was likely to foster hypocrisy. The Test Act made no attempt to determine a person's genuine beliefs. It simply required taking communion in the Church of England within the preceding 6 months and an oath abjuring belief in transubstantiation. This excluded dissenters of integrity from holding office. It did nothing to exclude those willing to pretend. When Jefferson complained that established religion tended to beget habits of hypocrisy, this is what he was talking about. There were also specific penal acts, suppressing the practice of faiths whose tenets were thought to be inimical to the regime. The Act Against Papists and the Conventicle Act prohibited unlicensed religious meetings. Various other statutes punished dissenters for engaging in prohibited religious worship. At first, Catholics, Puritans, and Quakers were the particular targets, because they appeared to threaten the political legitimacy of the state. Presbyterians took on this unwelcome role from the 1660s to the 1680s, especially in Scotland. The flavor of these laws is indicated by their titles. An Act to Prevent and Avoid Dangers which May Grow by Popish Recusants, or An Act to Retain the Queen's Subjects in Obedience. The United States Constitution explicitly forbade all these types of laws. Whatever else it might mean, The Establishment Clause bans any American version of the Act of Supremacy or the Uniformity Acts. The Test Clause of Article 6 bans the equivalent of the Test and Corporation Acts, and the Free Exercise Clause prevents any American version of the Penal Acts. Establishment in the American Colonies. Established religion came to America's shores with the earliest colonists. It assumed two principal forms: an exclusive Anglican establishment in the southern states and a localized Puritan establishment in the New England states, other than Rhode Island. Although equally coercive, the Anglican and Puritan establishments were profoundly different in spirit. The New England establishments were based on the intense religious convictions of Protestant dissenters, often in opposition to English authorities, whereas the Anglican establishments enjoyed the support of the Crown and were designed in part to foster loyalty and submission to royal governance. These two forms persisted throughout the colonial period, and the New England form endured several generations after adoption of the First Amendment. Despite their differences, the two types of establishment had many legal elements in common. In England, the Church of England was governed by bishops beholden to the Crown for their position. The Bishop of London's jurisdiction extended to the American colonies. Since there were no bishops on the ground in America, day-to-day authority over local Anglican churches was effectively exercised by a committee of laypersons called the vestry, elected by freeholders of the parish to control the local purse strings. The vestry was almost always composed of leading landowners. Thus, church structure was effectively oligarchic, in contrast to the monarchical character of the Church in England and the more republican character of New England churches. When the independence movement gained momentum after 1774, patriot vestries frequently came into conflict with Tory clergymen who had taken oaths of allegiance to the king. Such ministers were often ousted, sometimes were violently assaulted, and frequently fled. The most elaborate set of laws comprising an establishment of religion in colonial America was Virginia's. Before independence, Thomas Jefferson counted at least 23 applicable English statutes, dating to the reign of Edward VI, and 17 Virginia statutes, dating to 1661. Virginia's diocesan canons of 1661 are especially informative. They catalog the legal provisions necessary to sustain an establishment. The canons required the people of the parish to erect churches at public expense and to set aside profit-making land for the financial support of the ministry, called glebe lands, set forth rules for the selection, powers, and duties of the vestries, prescribed that ministers would be inducted only if they demonstrated ordination by a bishop, approval by the colonial governor, and selection by the local vestry, set the minister's salary, and gave him a cause of action if the parish failed to pay, prescribed liturgy, sacraments, and catechism to be performed only in accordance with the Church of England, mandated observance of the Sabbath and various holy days, including a day of fasting in honor of martyred King Charles I, as well as weekly sermons and biannual celebration of the Lord's Supper, authorized vestrymen to bring misdemeanor charges against persons caught swearing, Sabbath-breaking, skipping church, slandering, backbiting, or committing the foul and abominable sins of drunkenness, fornication, and adultery, required local churches to maintain official registers of births, burials, and marriages, limited lawful marriage to ceremonies performed by ministers of the Church of England, and set aside public land for a college and free school for the advance of learning, education of youth, supply of the ministry, and promotion of piety. Subsequent legislation addressed such matters as the effect of baptism on slave status, none, the punishment of such ministers as shall become notoriously scandalous by drinkingness, swearing, fornication, and other heinous and crying sins, and prohibition of unlawful disturbances of divine service. Of particular note were laws fining schismatical persons, who refused to have their children baptized, prohibiting the immigration of Quakers, and outlawing Quaker religious assemblies. A similar model of establishment prevailed throughout the South, though in the Carolinas and Georgia there was much greater toleration of dissenters. The Puritan establishment in New England had a different structure, decentralized and more democratic. Based on their reading of the New Testament book of Acts, most New England Puritans believed that church authority is vested in the people of the local congregation, who elect lay leaders to govern the church and hire ministers. There are no bishops or the equivalent.
Sample complete. Ready to continue?